Hello, finance friends. In this lecture, lecture 10, we're going to talk about estate planning. And this fittingly wraps up the personal financial journey that we've been on over the course of our previous videos. So what we're going to do today is we're going to start off by talking just generally about what estate planning is, talk about the goals of estate planning, and then dig a little bit into the tools of estate planning. What are the different, remember, one of our big themes in the way that I teach this is the right tool for the job, okay? Another theme, as I've taught it, is that there's the 4 buckets of activity. Have to earn the money, use it well day to day, grow it with investing, and protect it. So when we talk about estate planning, what we're really talking about is the protective function. It's not insurance per se, but it's a protective function. And we're going to tie that idea with the idea of finding the right tool for the job. So let's start up on top and then slowly drill down and get an idea of the tools. We'll dissect the different tools, do a little bit of nitty gritty, and at the end, have a step-by-step checklist of things that you can do to start preparing for your estate plan. So again, we'll start off at the top. What is an estate and what is estate planning? Well, first thing is your estate is just the general term for all of the assets that you own at the time of your death. So this is obviously a difficult topic to discuss for some people. We have to treat it with respect, but the reality is, 1, we're all going to die. And 2, hopefully, before we die, we've accumulated and accrued assets to help us fulfill our goals and live our dreams. So estate, the term estate refers to all of the assets that you own at the time of your death. And from that, we get an estate plan. And an estate plan can be seen as simply a collection of legal documents, the tools for the job that, number 1, lay out your intentions and your goals for after you're dead, and then number 2, helps you achieve them. So an estate plan is just it starts off with you making plans and having goals, but the estate plan itself is the collection of legal documents and other documents that helps you to fulfill those goals. It lays out your intentions and gives the legal backing so that those intentions are fulfilled. Ultimately, estate planning, it's a process. Like many other things in personal finance, it's a process. In this case, the process starts off with asking, number 1, who is going to receive your assets when you die? This is one big part of estate planning, whether you have a long life or maybe a short life. If you have assets that you've accrued and those assets exist, that estate exists when you die, one of the first things that you want to establish, who's going to get those assets when you die? We typically call those people beneficiaries or heirs. In addition, an estate plan, if you have children, an estate plan lays out guidance for who will take care of any minor children that you have. Now, it's important, estate plans and children, it works, or it comes into play if you have children who are minors when you die, because minors cannot make their own decisions. So you, as the parent, will have to make decisions on, if you die while your children are minors, what assets will they get, but who will steward and watch over those assets for them, because minors don't have legal control over it. In addition, who is going to raise your children if you and your partner die when the children are still minors? And then number 3, oops, let's go back here. Number 3, notice that numbers 1 and 2 tied into when you die, which is what an estate plan generally is. However, number 3 shows that estate plans can also kick into effect when you're alive but incapacitated. whether it's by terminal illness or mental or physical incapacitation or disability. If something happens when you're still alive, but you're unable to make decisions for yourself or for others, an estate plan addresses that. So again, an estate plan is a process of answering some really important questions. Who will get your assets when you die? Okay, who are your beneficiaries? If you have minor children when you die, who will take care of them, provide for them, and steward the assets that you leave to them? And number three, in case you don't die, as opposed to become incapacitated mentally or physically, who will take care of your personal and financial affairs? And what kinds of end-of-life decisions might be made on your behalf if you cannot make them yourself? So number one, there's some sensitive stuff here. It's very difficult. And especially if you've had people close to you die recently, this stuff can really hit a raw nerve. So we're going to treat it with respect, but we're also going to treat it as something that needs to happen. Okay, so that's the estate planning process. Notice once again, I had said at the beginning that estate planning is ultimately, it's about protecting assets. Okay, we have those four buckets. You have to earn money, use it well day to day, grow it with investing, but also protect it. Up to now, our protection has been while you're still alive with insurance, or when you die with life insurance. But now we're expanding this idea of the protective functions in personal finance to protecting for your loved ones after you die. So we're still in the realm of a protective function. We're protecting assets, but in this case, what we're really protecting are not what's, meaning the assets, but we're protecting whose. We're protecting the people that you love, that you care about, that you want to be taken care of after you're gone. Okay? So it's a protective function, and ultimately, it's a process that requires setting up goals and finding the right tools to achieve those goals. Now, one of the ways to think about an estate plan is to actually take a step back and ask a very difficult question, but from a very technical, legally, financial point of view, what actually happens when you die? And there's a few things, a series of events that occur when you die. Each of those events having underneath them a lot of decisions and the execution of particular strategies or tasks to get things done. Okay, so first thing that happens when you die, your assets become your estate. So right now, I'm alive. My name is Eric Young, and Eric Young owns assets. The moment that I die and Eric Young ceases to exist, Eric Young cannot own assets because he's gone. So instead, a new entity called the estate of Eric Young, that is created. So your estates become your asset. Once that happens, the assets in your estate, they have to be identified and valued. This is for both your cash assets, your investment assets, as well as your tangible personal assets. And if you own property, your property assets. So all of your assets, which is your estate, they have to be identified and valued. This process, by the way, is known in the probate world as inventory and appraisal, or I&A. So I&A, inventory and appraisal, is the process by which your executor or your representative, the person who you nominate to take care of your affairs once you're dead, that person has to identify all your assets and value them, and then submit that document, that I&A, to a court to illustrate and to demonstrate what you have. Okay. In addition, little tasks have to be done. Taxes have to be filed and paid to the IRS and to your state if applicable. So taxes have to be filed, and if you owe money, taxes have to be paid. Any final bills and liabilities that you have at the moment of your death, maybe some credit card bills or some medical bills or hospital bills, those final expenses, they have to be identified and paid as well. Once your assets have been identified, and then those assets have been used to pay your final taxes and your final bills and liabilities, any remaining assets, that's really what we think about when we think about the transfer of assets. So we have all the stuff that you have when you die, that has to be reduced by the amount required to pay for your taxes and your final bills and liabilities. Whatever's left over, those assets have to be transferred to your heirs and beneficiaries. And that property transfer process is a real big part of what happens after you die. Note that that may require a process called probate, which we'll discuss in a bit. Ultimately, when you actually die, a lot of decisions have to be made. And those decisions have to be made by somebody that you trust. If you handle your estate plan well, number one, you will have put together a series of documents that lay out all of your assets, that list all of your liabilities, that tell who you want your remaining property transferred to, that helps navigate through probate, and critically, who names somebody that you trust to handle this process for you when you can't. So ultimately, think of probate as a very lengthy and somewhat high stakes game of decision making. You want to make sure that while you're alive, you do whatever you can to ensure that the decisions that are made after you die are as easy to make as possible. So you have to get the right documents in place, get everything organized, and select somebody who you trust and who you can rely on to execute your estate when you're gone. And that's what happens when you die. Now, with that, we can kind of jump to the estate planning process. And ultimately, the estate planning process, it can be simple for some people. It can be complicated for some people. A large part depends on both your asset base and on the level of complexity in your life. If you're single with no children and, all of your assets are cash assets or investment assets, maybe a car and some personal stuff, but no real property, it could be a very simple process, a very simple plan. But as you maybe get wealthier and you have more assets, or if you own real property, or if you own properties in different states, or if you have a spouse and children, or if you have a spouse and an ex-spouse and children, or what if you have a blended family where you have an ex-spouse and kids with that person, and a current spouse and kids with that person, and maybe your current spouse brought in their own kids from a previous marriage. Now, all of a sudden, things got really complicated. But regardless of the level of complication, estate planning comes down to 5 steps. Step 1, you're going to look at your current finances and your current life situation and determine if you need an estate plan, which you probably do, and critically, what kind you need. Number 2, you're going to develop estate planning goals. You're not going to be around when this thing is drawing itself out. So you have to be really clear up front. What do you want to achieve through this process? And I'll share some ideas in the next slide. You then need to evaluate different estate planning strategies, including identifying the right tools for the job. Once you've done that, you're going to implement your plan. You're going to implement your plan. And although there's a whole array of tools available, you're going to implement your plan having at minimum two important documents established. Number one, a valid will, and number two, a document that we call a durable power of attorney. And then once you have those first four things done, you now have an estate plan in place. Congratulations. But there is a fifth step, as there is in any personal financial process, and that is you must revisit and revise your plan. I would suggest that you revisit it annually to make sure that everything is still appropriate. At minimum, though, you're going to revisit and revise your estate plan anytime your life circumstances change. You move, you buy or sell a home, you get married, you have children, you have grandchildren. Any of these major life events, these milestones in life, are also going to be, or should be for you, little mental triggers that say, I just had a major change. I better go back and look at my estate plan, because if my life circumstances change, then I probably got to change my estate plan to reflect that. Now, we had set up here that you're going to want to develop some estate planning goals. And I would recommend, or I would at least get you thinking that there's a couple of goals that should be universal for all of you. Okay. The first goal, which is ironic given the fact that estate planning deals with your death, but the first goal should be that you live fully, that you live a great life, that you flourish while you're alive. That should be one of the first goals of effective estate planning. That you build up great connections, that you have a lot of love around you, that you've got people that you care for, maybe charities that you support, that you've got a great life while you're alive. That's one goal. Another goal of effective estate planning is to make sure that any property that you have passes upon your death according to your wishes. In other words, who are your heirs and beneficiaries? What do you want to leave them? You want to make sure that your property passes upon your death according to your wishes. Now, you might be seeing that and say, well, of course it's going to pass upon my death. It will. All property will pass when you die. The question is, will it pass according to your wishes? Because if you don't have the proper estate planning documents in place, especially a will, your property will still pass, but the decisions on who gets your property will be made by a probate court or by a person who comes in and executes your estate. And their interests and goals and wishes may not align with yours. So make no mistake, your property will pass, but you want it to pass according to your wishes, to the people, the charities, the organizations that you value. Okay. Number three, critically, if you're a parent, you need to protect the interests of your minor children. And this implies both setting up guardians for them and making sure that those minor children are financially taken care of. Another major goal of effective estate planning should be to preserve family harmony. It is, I'm involved in the state of California, in the probate community, and in the, I'm not an estate planner, I'm not a lawyer, but I'm involved in the broader community of people that kind of work through estates and trusts. And one thing that you learn when you do that work is just, if you don't have a good estate plan, just how bad that is for the family that you leave behind. I can't even begin to describe to you the extent and number of cases that you hear about when you do estate planning work, fiduciary work, probate work, when there's a bad estate plan or, God forbid, no estate plan. I mean, it is very common when somebody dies for that person's survivors to go to war with each other. Lots of hidden bitterness and lots of bottled up anger and frustration and jealousy and human emotion have a tendency to just fly to the surface and boil over when you die. And if you don't have a good plan, there's a good chance that the people that you leave behind will rapidly move from grieving you to fighting each other. It's a sad but true fact of estate planning and of the world of fiduciary and probate work that families disintegrate and they go into civil war if you mess up your plan. So if you love your family, one of your goals should be to preserve family harmony, to keep your people after you're gone tight, to prevent flare-ups and civil wars. And you can only do that by making everything as detailed as possible so that they don't have a chance to bicker. Everything that you wanted is laid out, and those are your wishes. Okay. You also want to avoid probate. We'll discuss probate in another slide, but probate is basically a process by which a county probate court looks over your will, determines that it's valid, and then administers the distribution of your property. Probate is, depending on how you set up your affairs, necessary, but if possible, you want to avoid it, and we'll learn how. For those of you who find yourself, especially as your life situation changes, in unique situations, maybe you have a blended family, maybe you have children from a previous marriage, and so does your spouse. Maybe you're married, and each of you and your spouse, have children from previous marriages. You have these blended families. Or maybe you have a child with special needs. Or maybe you have a child that maybe has, sadly, a gambling addiction or a drug or alcohol addiction. All of these unique situations you really want to think about and prepare for. And they're difficult situations, but one of the beauties of good estate planning is there are almost always tools that will help you to handle and navigate through unique situations. And then finally, for some of you, for those of you who, when you die, are extremely high wealth, another goal of estate planning might be to minimize tax burdens as well. Okay, so those are the goals. The question then is, how do we achieve those goals? And the answer is, you achieve those goals by having the right tools for the job. Ultimately, like we said earlier, an estate plan is a collection of legal documents. These legal documents are just tools to get the job done. What job? These jobs. So those are what the documents are. Your estate planning documents are just the basic tools, the building blocks to get the right job done according to your wishes. Remembering always that with an estate plan, you're dead. So you're not going to be around to clarify or lay out or modify your wishes. Now, there are a lot of different planning documents, and there's many, many types. Generally speaking, you can get by with the big four, and you don't even need all four of them. But when it comes to estate planning, the most common documents, the big four, are the following. Number one, your will, also known as a last will and testament. Your will is the document where you lay out your wishes of how you want your property to be distributed. And in a will, you also lay out provisions for your minor children. We'll discuss a will, again, also called your last will and testament, in a later slide. Another document is a durable power of attorney. We'll discuss this also in a later slide, but think of it this way. Your will lays out your wishes for when you're dead. Who handles and distributes your property, where it goes, how your minor children are taken care of, who takes care of them after you're dead. A durable power of attorney is a document that kicks in when you're not dead. You're still alive, but you're incapacitated. You have an accident, an illness, something really bad. These are not pleasant things. And you are no longer, either because of this terminal illness or this physical or mental incapacitation. Maybe you have a really bad stroke, a bad accident. Lots of things can happen. If something happens where you're still alive, but you don't have the ability to make decisions due to incapacitation, that's where the durable power of attorney kicks in. It also, the durable power of attorney gives, so this is tied to incapacitation, and the durable power of attorney is also a way where you can lay out and codify your end of life wishes. Do you want to be resuscitated? What kinds of end of life care do you want? Again, very difficult, very, very difficult things to think about, but you've got to think about them, okay? Because no man is guaranteed tomorrow. I would argue that everybody needs these two. So of the big four, you probably need ASAP, a last will and testament, your will, and a durable power of attorney. Other big four documents are the letter of last instruction. The letter of last instruction, it's non-binding, so it's not a legal will, but this is a document that sort of accompanies the will. And what you do in your letter of last instruction is you give the person called the executor. Okay, your executor is the person who executes your will. So they're called the executor. So when you make a will, you're going to name the executor of your will. It's the person who will execute your wishes. Now, because nothing in personal finance can ever be simple, and it has to always be jargony, executors have different titles as well. So if it's a male, it's an executor. If it's a female, she's called an executrix. And this can also be called a personal representative. So a lot of jargon, but whether it's a personal representative, an executor, or an executrix, this is the person who fulfills your wishes and executes what is laid out in your will. What the letter of last instruction does is just that. It gives instructions and details that will help your representative, help your executor do their job effectively. Your letter of last instruction can include things as diverse as your wishes for your end of life and burial stuff, the location of any major documents. For those of you who have extensive online lives, passwords and usernames for all of your accounts. For those of you who have financial documents emailed to you, your username, login information for your email accounts. In other words, your executor is going to have a lot of stuff that they have to do. This letter of last instruction helps them out. Like I said, passwords, the location of important documents. How about this? A list of the people along with their phone numbers that you want your executor to call to let them know. None of these things are codified in your will, but by putting them in the letter of last instruction, you'll make this person's job much easier. My letter of last instruction to my executor actually lists all of my assets with all the passwords and the usernames for the websites. It has all of my PIN numbers. It has a list of people I want my executor to call to inform them. And it just has other things that I think might be helpful. so that this person, my executor, can do their job effectively and efficiently to wrap up my estate. The last of the big four is called a living trust. Now, you hear a lot about trusts, and they are a potentially valuable part of an estate plan, but not everybody needs them. We'll discuss those in a later slide as well. In addition to the big four, there are a handful of other documents, other optional documents. These include advanced medical directives, where you give your thoughts on what type of end-of-life care you want, if you want to be resuscitated. These are pretty difficult documents because when you do them properly, you're really thinking about, and you'll usually do this with a lawyer, you're going through a whole series of exercises where there's, you have to effectively think through, brainstorm, and role play lots of the different ways that you might grow ill and die. And you have to think those through and lay out what you would want or not want in different situations. Again, painful to think about, but it's better to have it prepared and not need it than to need it and not have it. Funeral wishes, it's always a good idea to lay out what you want for your end of life and for any kind of funerals. Or maybe you don't want a funeral. Or if you want a funeral, maybe you want it done in a certain place. Maybe you want Eye of the Tiger by Survivor to play when they're taking you out of there. Maybe you've got all kinds of wacky wishes. Whatever it is, though, you better codify that to give guidance to the people who you're going to trust to handle your affairs. And then a very common thing that people do are personal letters. Lots of people will write letters while they're alive to the people that they want to say a final goodbye to. People you love, people you admire, and just let them know what they've meant to you. Sometimes personal letters are also used if in your will you don't give particular people certain things, or if you have an unequal distribution of assets in your will. Some people use personal letters to also explain their reasoning. But either way, it's one final way for you to say goodbye to people. And I think these are really good for people that you love, family, friends, loved ones, children, to really let them know, your final goodbye and how much they meant to you. Very emotional stuff, but again, a way that you can craft your exit from this earth. So those are your basic documents. Now, we had said that one of the goals, this goal right here, one of the goals of effective estate planning is to transfer property according to your wishes. So in this slide, we need to really think about the transfer of property. And from a kind of a technical legal estate perspective, there's four broad ways that there's four broad ways that property can transfer. The first way, property can transfer via a will. So you have a will, and in that will, you name your heirs and your beneficiaries. And you put explicitly, I want to leave my watch to this person. I want to leave a sum of this much money to that person. I want my retirement account to be divided in this percentage to these people. Very explicit, specific distributions named in your will. That's one way. Another way that you can transfer property, however, is outside of a will. So think of it this way. You can transfer property with a will, and then there's other ways to transfer a property, what we can say, outside a will. One way to transfer property outside of a will is via contract. Now, what this means is if there's contractual forms set up, you can actually transfer property through contract and not through will. In the real world, this basically comes down to two different ways. Number one, ownership provisions. In other words, it's possible to have what's known as joint tenancy, effectively where you co-own property with somebody. If you co-own, so if you own a house and you own that house in joint tenancy with somebody else, when you die, since you're joint owners while you're alive, when you die, the house just goes to them with no need for it to be in the will. Okay, so ownership provisions and ownership contracts are one way to transfer property outside of a will. Another way is via what are known as beneficiary designations. These are typically in retirement accounts, brokerage accounts, and possibly bank accounts. It works like this. Suppose that you have a 401k account, so you set it up. What you do when you set up your 401k account, and every retirement account has this, you just have to look for it, you set up a beneficiary designation. The beneficiary designation effectively says who gets the account when you die. You can have one beneficiary who gets 100% of the account. You can have multiple beneficiaries where you split it up. You can split it up evenly, or you can split it up skewed. It's all up to you. But here's the key. When you set up a beneficiary designation, the moment that you die, the property, the account, is transferred to your beneficiaries immediately as established in your designation. Since it's transferred via contract, via designation, you don't need a will to transfer it. So you can bypass a will by transferring property via beneficiaries. Real quick, when it comes to bank accounts, you're going to look for something called a TOD or a POD. That stands for transfer on death or payable on death. So I, for example, have my personal checking account. It's my account. It's in my name. It holds my cash. I pay my bills through it, as we've learned. But my checking account has a POD designation. So my checking account says Eric Young, POD, with a name there. And what that means is when I die, the moment that I die, that checking account, the entire balance, simply legally transfers to the individual that I named as my POD, as my payable on death. Or it's also called a TOD, transfer on death. So the third way you can transfer property via a trust, which we'll talk about in another slide. And then the fourth way that property can transfer via law. I had said in an earlier slide that property will always transfer. It just might not transfer according to your wishes. That's what this one means. If you die without a will, okay, this is known as dying intestate. Intestate, again, testament, last will and testament. So testare, testamentary, intestate, this is all rooted in the Latin word for will, okay? If you die intestate, that means that you die without a will. Does that mean that your property just disappears? Or the state of California jumps in and tries to steal it? Well, they might, but technically no. If you die intestate, if you die without a will, your property is still transferred, but it's transferred according to the laws in the state of California and according to what a probate judge says. And this may not coincide with your wishes. Imagine that you are unmarried, but you have a life partner that you've been with forever and you intend to be with forever. If you're not married, though, and they're not your spouse, and you die intestate, nothing in California law provides for your property to go to a life partner. Instead, if you die intestate, the order is, I believe, the property goes to first, I believe it's spouse. If you don't have a spouse, then it's kids. If you don't have kids, I think it's to a parent. So there's a whole succession of people who are entitled to your assets if you die intestate. But what if you don't want those people to get it? What if you want your life partner to get it? Well, if you die without a will, then the law is going to dictate where your assets go to. And that might not coincide with your wishes. This idea of dying intestate is it's never good. It's especially bad if you are unmarried, but you're in a committed life partnership. And then up until recently, when laws changed, this was especially an issue for same-sex couples. Prior to same-sex couples being able to marry, same-sex couples might be together forever, but they could never get legal marital status. It was essential that the same-sex couple had a good will or a good trust that made sure that the surviving partner got the assets. You can imagine, let's go into a really shitty case scenario. Imagine that you're in a committed relationship, unmarried, maybe same sex, maybe hetero. And let's say that your parents don't approve of your lifestyle or don't approve of your partner. If you die without a will, there's a very good chance, if your parents don't approve of your lifestyle or your partner, there's a very good chance that your parents could legally say they don't get a dime. They might say, I've been with them forever. We're life partners. And your parents can say, show me a will. Where are you listed? And they'd say, well, he didn't have a will. And your parents could legally say, then you don't get a penny and get out of here. Okay? That's never good. It's very ugly to think about. But again, these are the things that you have to think about. You have to open your mind to different potential scenarios, both good and bad, and then get the right tool for the job. Okay? So to summarize this slide, there are 4 ways that property can transfer, either via a will or outside of a will. Outside of a will being via contract, beneficiary or ownership status, via a living trust, or if you blow it and don't plan, via the laws of the state that you live in, which may not coincide with your wishes. So, we've mentioned earlier the term probate. Let's now talk about what probate is. So ultimately, probate is just a broad term. It has a specific meaning and then a looser meaning. The specific meaning is this: probate is the legal process in which the dead person's will is reviewed by a court. It's called the probate court. It's called the probate judge. So in probate, the probate court reviews your will to make sure that your will is valid and authentic. If the probate court says, yes, we determine that this will is valid, is authentic, is genuine, then the probate court will give your executor the formal permission to execute the will. By the way, after the probate court does this, they will give your executor a very specific document known as letters testamentary. Once again, that root right there. Letters testamentary is the official acknowledgement and the official directives of a probate court that your executor has the authority to act on your will. Technically speaking, your executor cannot start distributing property until the probate court says you can. Now, that's what probate technically is. In recent decades, the term probate has also sort of expanded. So now probate also refers to the process. So now probate is not just the legal process where the court says do it, but probate now refers also to the ongoing process by which your will is administered. So again, from the very technical legal thing, probate is when the court approves the will as being legitimate, valid, and authentic. But from a more practical perspective, the term probate now also expands to mean the process by which your executor actually administers your will, pays your final bills, distributes your property, and wraps it all up. Now, that all sounds fine, but whenever possible, you want to avoid probate because probate has several disadvantages. Number one, probate is time consuming. In the state of California, it is estimated that even a super simple estate might require a probate that can last anywhere from 12 to 18 months. And in that time, your property is effectively tied up and cannot be fully distributed to your heirs and beneficiaries. So it's very time consuming and locks up your cash, preventing your preventing your heirs and beneficiaries from getting it. Number two, probate is very costly. The probate process is expensive, and it's a shame because probate is ultimately just checking off a lot of legal boxes, but it's a very expensive process. And the money has to be paid both to your executor and to their lawyer. Here's the thing. Probate is costly, and all those probate expenses come out of your estate, which means that more money goes to lawyers and less goes to your beneficiaries. And then the third disadvantage of probate is public. As soon as your will is filed in a probate court to begin the probate process, your will becomes a public document, and anybody can have access to your will and read it. And that would trigger knowledge of how much money you left and where the money goes to and family stuff. And maybe you don't want that to be known. So given the fact that probate is time consuming, costly, and public, a good strategy of estate planning is whenever possible, however possible, minimize the amount of assets that go through probate. So how do you do that? Well, you already know the answers. I'm asking the question here, what assets go through probate? What assets avoid probate? Well, assets that go through probate are all assets owned, I'll say this, owned solely by you without a beneficiary designation. If you own an asset solely and it's owned in your name and it does not have a beneficiary designation attached to it, like a retirement account could, that's going through probate. You have a car, the car's in your name, it's going through probate. Notice that what goes through probate are basically all the assets listed in a will. In addition, probate would cover any assets you forgot to include in your will. So let's think about this. You have a will and you have a car and you have your will, and you say in your will, I leave my prized 2002 Honda Accord with the cracked windshield to my sister. Okay, that's listed in your will. It's going through probate. But let's say that after you write your will, you go and you buy a new car. If you forget to add that new car into your will by amending your will, in other words, if you acquire assets after you write your will that somehow are not covered in your will, those are still going to go through probate. Okay. So probably the best way to answer the question of what goes through probate is to ask what assets avoid probate. And we already know the answer. Assets that avoid probate include assets with a POD, TOD, or beneficiary attached to them. Number two, any assets that are jointly owned by you and somebody else avoid probate. And third, any assets held in a trust avoid probate. So now you can see, A, that probate's expensive, why you want to avoid it, and then how you avoid it. And if you notice down here, we're bringing up things that we referenced earlier. So we referenced the idea of dying intestate. We referenced that property can transfer via contract or via trust. We established up here that the living trust is a potential estate planning document. And we set up here that one of your goals is to avoid probate. Okay, so that's what we're talking about in this slide here. So anyway, so these are assets that go through and avoid probate. Let's wrap this up now with a little deep dive into our into a deep dive into our documents. The first of the big documents is your last will and testament. So what is this document about? Well, your will is ultimately a legal document that lays out two big things, actually several big things. But what a will does is it indicates, number one, how you want your assets to be distributed when you die and to who. And number two, if you have any minor children, how will they be taken care of and by who? Remember, if you die without a will and you have minor children, the courts are going to decide who watches over your children. And they may not share your view on who the best guardian might be. You cannot leave this detail unattended to. A last will and testament is also where you're going to nominate and name your executor. So in your last will and testament, you're going to name your executor, your personal representative, and then tell that executor who gets your stuff and how your kids are going to be taken care of. Okay, so in your will, your executor or personal representative, they carry out your wishes. We've already discussed what dying intestate means and that you don't want this to happen. What are the benefits of a will? Well, number one, wills are now pretty easy and simple to do, and they're fairly inexpensive. Benefit number two, it's the primary way that you establish guardianship. And number three, it's a very, very simple way to distribute assets. The primary disadvantages of a will is that they can be somewhat hard to tailor to unique situations. And critically, everything in a will, as we just learned, must pass through probate. So you're going to need a will, but notice that your will may not cover all of your assets. Think about this. Watch this. Suppose that somebody has, $1 million in assets. But of those assets, $950,000 are retirement accounts with a beneficiary designation. That property is going to transfer by beneficiary. So even though you have $1 million of total assets, If 950,000 of that is transferring via beneficiary or is maybe held in a trust, then technically your will is only transferring $50,000 worth of assets. Okay. Now that's supposed to go through probate, but it's much better to put 50,000 through probate than $1 million through probate, and much cheaper too. Okay. So again, just there's a lot going on here, but understand that the primary disadvantage of a will is probate, but then further understand that not every asset that you own is what we're going to call probatable. Some assets are non-probatable. They avoid probate, specifically 1, 2, 3, those assets there. All the remaining assets that are probatable, those probably in your will, those probatable assets go through probate. But it's important to realize you could have a really, really, really big net worth, a lot of assets, but actually have a very, very small probatable base if the bulk of your assets are in trust or jointly owned or have beneficiary designations. Okay, so that's a last will and testament. Earlier, we discussed a durable power of attorney. Let's talk about that briefly. There's another document, and again, the jargon gets messy. This is called a living will. Now, it's really easy to get confused, so let's be real clear. This one, the last will and testament, is a legally binding document that you need to have. A living will is sort of an optional document. And critically, it is not legally binding. So you think, well, why do I need it? Well, what a living will is, this is a document that really reflects the advances in medicine of the last, maybe 50, 60 years. People are living longer now, and that's a good thing. But it also means that, sometimes people have prolonged deaths or deaths that are due to disease or terminal illness or incapacitation. So a living will is a document in which you specify several critical things. Number one, primarily, what kind of end-of-life care, what kind of end-of-life medical care do you want, and do you refuse in the event that you can't make decisions for yourself? In other words, something bad happens, you have an accident, you have a stroke, you have a terminal illness, you are unable to make decisions for yourself anymore. A living will, if written beforehand, specifies what kind of end-of-life care you want. Do you want resuscitation? Do you not? Do you want to have a full extent of things to keep you alive? Do you not? Will you want to be kept on life support? Will you not? All of these difficult decisions can be codified in a living will. The problem is, a living will is not necessarily legally binding. And therefore, we have a document called a durable power of attorney. And a durable power of attorney is a legally binding document in which you appoint someone. It better be someone you trust, someone who you know will execute your desires, and somebody who can handle a lot of pressure. But if you can find that person and they're willing, you make them your durable power of attorney. Because by naming them in that document, they are appointed. They are given the legally honored authority to make specific medical decisions on your behalf when you can't. And then finally, we have the trust. Now, a living trust, technically speaking, the legal name is an inter vivos trust. Inter vivos, Latin for basically while you're alive, hence the term living trust. The best way to think of a living trust, it's a legal entity, and it sort of acts like a container to hold your property. So let's say that I am Eric Young. So I am Eric Young, and I am a legal living person. That's me in that little circle. If I establish the Eric Young always wears black polo shirts trust, I establish the Eric Young Black Polo Trust. This trust is basically a separate legal entity. I, Eric, am one person, and my trust is a legally separate, legally distinct entity. It's called a living trust because I set it up while I'm alive. Critically, what you do is you transfer all your assets, your retirement assets, your bank accounts, your cars, all of your assets, you transfer to your living trust. And once they're transferred, get this, you, as the person, no longer owns the assets, but your trust, as a legally separate entity, does. The trust, in turn, is a legal document that dictates how the property it holds is going to be used both while you're alive and while you're dead or after you die. So think about this. I set up the Eric Young Black Polo Trust. I transfer all my black polo shirts, my checking account, my IRA, and my 2002 Honda Accord with the cracked windshield into my trust. That means that I, Eric, no longer own the trust. Sorry, pardon me. I, Eric, no longer own the assets. I don't own anything anymore. My trust owns them. Now you think, well, Eric, that's a pretty shady deal, because how then will Eric get by? Well, here's the beauty. Check this out. Every living trust has three components. Component number one is the grantor, also called the settlor, also called the trustor. This is basically you. This is the person who sets up the trust. Notice that if I, Eric Young, set up the Eric Young Black Polo Shirt Trust, I'm the grantor. I established the trust. The trustee is the person who handles trust assets. The person who has the legal authority to handle the assets in the trust, to sell them, to use them, to collect income on them, to spend that income, that's the trustee. But here's the beauty of a living trust. As long as you're alive with the living trust, not only are you the grantor, but you're the trustee. And the beneficiary is the person. So this is the beneficiary. This is the person who benefits from the assets in a trust. When you die, your heirs, the people who get all your assets, those are the beneficiaries. But get this, once again, in this really cool little legal fictitious entity, while you're alive, you are also the beneficiary. So when you set up a living trust, while you're alive, you are the grantor and the trustee and the beneficiary. What this basically means is that when you set up a living trust while you're still alive, you have full use, full access, full power over all the assets in the trust. It basically is the same as if you didn't have a trust and it was in your name. So you say, well, then why do I want this? Well, here's the reason. As soon as you die, your trust then, since you're dead, once you die, you're no longer the trustee or the beneficiary. Once you die, a successor trustee who you name in your trust takes over the trust. And that trustee distributes all your assets to the beneficiaries that you lay out in the trust. So basically, a trust allows you to have full access over all of your assets, cash, property while you're alive. And then the moment that you die, you're gone. The trust then still fully owns the assets, and the what we call successor trustee that you nominate has access to those funds to distribute those funds and assets to the other beneficiaries that you nominate. Okay. Sounds kind of complicated, but it's really not. You just got to remember that there's two separate people, you, the person, and the trust as a separate entity. Okay. Now, a couple of things on this. Number one, living trusts have to be established, which means you have to set up the bucket, but they also have to be funded. One of the big mistakes that people make in the world of estate planning is they'll pay a lawyer to set up a trust. It's set up, but then they forget to transfer the assets into it. A trust with no assets is useless. It's also important to understand the concept of a revocable and irrevocable trust. A revocable trust means that, let's say that you're the grantor. If your trust is revocable, it means that you can change it at any time, in any way, whether it's simply modifying it, gutting it out, or even terminating it while you're alive. An irrevocable trust, on the other hand, once it's established, cannot change. The way that it works for most people is this. When you set up a living trust, it's considered revocable while you're alive, which again means that you, as the grantor, trustee, and beneficiary, have all access to the assets in the trust. But the moment that you die, from a technical perspective, since you're gone, the moment of your death, the trust becomes irrevocable. It can no longer be changed. And now the successor trustee goes in and simply does with the assets in the trust what you dictated. Okay. The final thing I want to discuss briefly, that there's special kinds of trusts. A lot of people will say, Eric, like, trusts sound very complicated. What are the benefits? Like, why would you do this? Well, benefit number one is, remember, trust assets bypass probate. Number two, trust assets can be distributed immediately upon your death. Since a trust doesn't need to go through probate, your successor trustee does not need a probate judge's permission. So that 12 to 18 month window it's bypassed. You know, quite literally, you could die today, and within a couple of days, your successor trustee can start distributing assets out of the trust according to your wishes. Advantage number three, trusts are also private. And the fourth advantage is trusts can be specially tailored based on unique needs that you have. So, for example, suppose that you have a child with special needs. This child may never be able to work. Well, there's a document called a SNT, a special needs trust, which is established specifically to provide for the needs of disabled children. Suppose that you want to give a lot of money to charity. There are what are called charitable trusts. Those charitable trusts allow, for example, upon your death, all of your property to go to a charity, or a portion to go to a charity. Well, how about this? Suppose that I have a partner, and when I die, I want two things to happen. Suppose that I want eventually all of my assets to go to a charity. Let's say the Friars of the Basilica of St. Anthony in Padua, Italy. Let's say I want my money to go to the Friars. Let's say that I have $1 million in my estate. I don't. Let's say I did. Well, suppose that I want that million to go to the Friars of St. Anthony at the Basilica in Padua, Italy. But I also want my partner to be taken care of after I die while she's still alive. You can do what's called a charitable remainder trust, which says this: I die, my trust becomes irrevocable with the provision that while my partner's alive, all of the interest and earnings and dividends on that million go to my partner. In other words, my partner can live off the interest. The $1 million stays intact. My partner lives off the interest. And then when my partner dies, the million, the charitable remainder, goes to the Friars. It's an amazing tool. There's trusts that are called spendthrift trusts. Let's say that you have beneficiaries that you want to take care of, but they're terrible with money. Well, if you have a will and you leave them money, the chunk of money goes to them in one shot. Maybe not a good idea if they have bad financial discipline. But under the terms of a spendthrift trust, you can designate that the money in your trust is paid out to your beneficiaries in little pieces over time, guaranteeing that they don't go out on a gambling or spending binge and exhaust all the money in a long weekend. You can imagine that if you have special situations, disabled children, beneficiaries with spending issues, or maybe gambling or substance issues, maybe you have a blended family, and you want to make sure that your children from your previous marriage are taken care of in a different way than your shared children with your new spouse. A trust is fully customizable and is tailored to any unique need that you have, and that's an advantage. There's a lot going on here. Let's end this lecture by thinking through, now that you know the basics of the tools, let's talk about the step-by-step way to set up an estate plan. Number one, while you're alive, you should go through the process of inventorying and valuing all your assets. Notice you should have already been doing this, number one, to go on your balance sheet, and number two, because you probably needed some record for your insurance coverage needs. So step one, inventory and value all your assets. Step two, think creatively about the people you love and ask, what types of protections do your family need? Note also that you can use your estate planning documents to also set aside money for the care of your pets. And if to you, pets are an important part of your life, if they're like a part of the family, you want them taken care of as well. That's a great thing. So think broadly, open-mindedly about the different types of protections that your family, that your pets might need. If you have minor children, identify guardians for them, people who share your values, people who share your faith stance. And after you identify those guardians, go out and speak to them. Say, hey, listen, I'm doing my estate plan. Can I ask of you, can I impose on you that if I die before my children reach the age of 18, will you take them? Will you guard them? Will you protect them? Will you raise them as my proxy in the way that I would have wanted? It's a major obligation. So identify those guardians. Determine where you want your property and assets to go and who you want it to go to. Then, whenever you can, set up beneficiary designations to make the distribution happen. Notice that by doing the beneficiary designations, you shield a lot of your property from probate. Create, print, and sign a simple will, and also set up at minimum your durable power of attorney. These documents at minimum you need. If you determine that it's appropriate for your own life, if your life situation dictates that you need it, then move ahead and set up and fund a living trust. Finally, the details: sign your plan and critically store it so that it is easily accessible. You oftentimes hear people talking about keeping their will in a safe or in a safe deposit box. You might not want to do that. Think about this. If my will is in my safe deposit box, when I die, my safe deposit box is frozen. My executor needs my will to prove to the court that I want my executor to have access to my bank account. My documents will have the combination for my safe so that my executor can get the important things out of there. So if you set up your plan and sign it, that's great. But if you store it in a way where it cannot be found easily, that's not a good move. Sadly, it's very common that people will set up a will and in their will dictate what they want for their final wishes. Then they put the will in their safe. They die. Their executor has no knowledge of where the will, they think it's in the safe or in the safe deposit box, but they can't have access to it. They then plan a funeral based on what they thought they wanted, only later to find out when they can finally access the will, oh, damn, the stuff that we did for the funeral is nothing like what this person wanted. So sign your plan, but store it so it's easily accessible. And then finally, anytime that you have a major life event, or maybe annually, quickly reassess and revisit your plan. Make sure that your provisions are still intact. Make sure that it still applies to your life. And that's all you have to do. Finally, if it sounds complicated, consider professional help, because there's a wide array of highly qualified estate attorneys who will assist you in laying out these documents. And that, my friends, is estate planning. And that's the culmination of our lectures. I hope you've enjoyed this course. I hope you learned a lot. And I thank you very much for your time and attention. And I wish you the best. Okay? Don't be afraid to be wealthy. Don't be afraid to dream big. Don't be afraid to make your dreams a reality. Future you deserves that. Make it happen. Thanks for your time, and I wish you the best.